You can remain on the phone, and your attorney can perhaps negotiate with the state and see if the state is willing to do anything. However, a warrant is going to be issued for your arrest.
Boom, that's the hammer dropping. A warrant means the defendant is now officially a fugitive until they turn themselves in. Question for you: if you were in her shoes, would you show up voluntarily, or hope they don't come knocking?
Okay.
All right. Do you need to speak with her? But you have her phone.
Right. I have a phone. Your
Is
Honor.
this going to end up being a contested hearing?
Yes, Your Honor. And that should get. Okay. One issue I have is right now. We just filed it. They just filed it.
This is not going today. My question is whether or not it's going to be a contested hearing. It's not going today.
No.
No. So
And another issue is bond. And apparently, when you file the MPR and Your Honor signs it, turns into a warrant. Does it not?
yes, it does.
Okay, so now she had no idea. They just put it. So I'm asking for a PR bond on this MTR, Your Honor.
Oh, the court is not going to grant a PR bond.
So that means that now she has a warrant and she has to come and turn herself in.
Yes. All right, Ms. Ferguson, can I have a 15-day reset for a contested hearing?
So do I have to turn myself in?
You need to speak to your attorney, but there's a warrant out for your arrest.
They didn't tell me any of this.
All right. Well, allegedly, you've never reported for probation.
Intro title before we jump into today's courtroom drama. Let me ask you something. How many chances should someone get before a judge finally says, enough is enough? In this case, a probation violator stands before the court asking for mercy, promising he'll change, and pleading for one last opportunity. But the judge isn't just listening to his words. He's looking at months of missed deadlines, broken promises, and repeated failures to follow court orders. Will the judge believe this emotional plea, or decide that enough chances have already been given? Stay until the end, because this hearing takes several unexpected turns, and the judge delivers a powerful lesson about accountability, responsibility, and the consequences of ignoring court orders. Let's get into it.
Definitely tell that that's there.
All right. So it's going to be reset for October 24th. What time?
Okay,
At 9
so
a.m.
is there any way to get it for November? Only because I'm out of state. As soon as I had bonded out, I had moved with my dad, trying for me and my kids, have 5 little girls. I'm trying to do everything I can possibly right to stay straight, to not get in trouble or anything. And with a warrant, I have 5 children. I'm a single mother.
Well, here's the thing. Allegedly, they're saying that you have never reported. So, I mean, they're saying you never reported.
And there's no way to get that MTR lifted.
You need to speak to your attorney.
I've tried, and this is the first time I've even seen my attorney.
Well, here's the thing, Miss Garcia.
Yes, ma'am.
The first time that probation allegedly is seeing you.
Right.
And I do believe that allegedly you probably don't have permission to have left Bexar County.
Yes, they told my dad when my dad had helped bond me out.
No. Here's the thing. I don't need to hear about your case. I'm just telling you that your court date is going to be on October 24th. A motion to revoke has been filed. If you would like to speak to your attorney by phone and your attorney has your phone, you can remain on the phone, and your attorney can perhaps negotiate with the state and see if the state is willing to do anything. However, a warrant is going to be issued for your arrest.
Okay.
All right. Do you need to speak with her? But you have her phone?
I have a phone, Your Honor. I can zoom in.
All right. Oh, sure.
I'll zoom in.
All right.
I just need the ID number.
All right, Ms. Ferguson, if you could,
Is that all, Your Honor?
no, you're to stay online.
Okay.
And Norma, saying
Yeah,
it.
who was supposed to show up for her FTR hearing,
Mhm.
contested hearing. Apparently she didn't show up.
All right.
I did talk to her over the weekend. She said she was on the way. Remember, she had left the state of Texas and gone to
Yes.
Missouri somewhere, and said she was coming back, but obviously she's not here.
All right.
So I've been waiting for about 45 minutes.
All right, we're gonna go on the record. Can I have someone from the state on Amethyst Garcia, please? Court is calling 2021 CR 2958 and 2022 CR 8569, State of Texas versus Amethyst Garcia. Can I have parties announced for the record for the state?
Brittany Sparks.
Defense?
Nipa Gallegos Carrillo.
All right, this hearing was scheduled at 9 a.m. It is now 9:55 a.m. Deputy Laura, is there an Amethyst Garcia outside the courtroom?
No, Your Honor, she is not.
And she is currently not in the courtroom either. Counsel, where's your client?
I talked to my client over the weekend, Your Honor. I reminded her about coming to court, that it was in person and that she needed to be here, that she was on her way into Texas. And I said, okay, then I'll see you on Monday. And that's as far as it went.
All right, state.
She asked that you forfeit her bond and issue a warrant.
All right, Caroline, is she on a PR bond or no?
She already has an active warrant, Your Honor,
Okay. And that's the active warrant on which case?
on that one. I believe the one, the NPR,
Okay.
I believe so.
All right. Well, the court will issue a bond forfeiture and remand your client without bond. If your client makes an appearance, then the court will reconsider. 21 CR 2958 and 2022 CR 8569, State of Texas versus Amethyst Garcia. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Nipa Gallegos Carrillo for Ms. Garcia.
And are you Ms. Garcia?
Yes,
Ms. Garcia, in cause number 2022 CR 8569, you entered a plea, and according to the plea bargain agreement, punishment is to be assessed at a cap of 5 years in the prison. There's a $1,500 fine. State is silent on your application. They're taking in consideration NIMAG number 688702. Have both parties had a chance to review the PSI report?
Yes, Your Honor. With my understanding that the cap was at 4, and that's
No, I'm just reading what's in the,
I understand it's capped at 5.
5.
Yes.
Okay.
all right. And then Ms. Garcia, I'm going to show you what's entitled Motion to Revoke Community Supervision and State's Motion to Supplement Pending Motion to Revoke Probation. Did you review those documents with your attorney? Did you understand them? I can't hear you.
Yes, ma'am.
Are you the same Amethyst P. Garcia who's placed on community supervision in 2021 CR 2958 for the offense of possession of a controlled substance, penalty group 1 gram or 4 grams on April 18, 2022 for a term of 5 years?
Yes, ma'am.
Violated condition number 1 on or about the 9th day of June 2022 in Bear County, Texas. The defendant, Amethyst P. Garcia.
That word, true, seals it. In probation world, pleading true is basically an admission. It hands the judge the power to revoke and impose prison time. No jury, no trial, just straight consequences.
Committed the offense of possession of controlled substance, penalty group 1, 4 to 200 grams, in violation of condition number 1.
How do you plead to that, true or not true?
Your Honor, we'll waive the remaining violated conditions.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 6 years in prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. I'm assuming there's no agreement on the motion to revoke?
That is correct, Your Honor.
All right. And the state is silent on 2022 CR 8569. In that cause number, defense, do you have any witnesses?
No, Your Honor.
All right, then the court will hear argument.
Well, on the, are you saying for the application for probation?
Yes.
Yeah, the application for probation. Now, when we were trying to negotiate all of this MTR and everything, so my understanding is, and of course right now I'm saying it's different, but my understanding is that the NPR agreement for the or punishment would be to run concurrent or to run together with the case that she plead on. So that's what, on that new case, Your Honor, we're asking this court to give her another opportunity. Now, she did not comply with her probation. In fact, she, as Your Honor can read, she didn't even start her probation. She didn't show up for orientation or anything like that, which caused the warrant and everything to come in. Now, she's realized she's been in jail since November of 2022. She realizes that this has to stop. And she picked up a new case. It doesn't get any better, Judge, it gets worse as you go along. However, I'm asking this court to give her another opportunity. And why should you give her another opportunity on probation is because I think that she realizes that this has to stop. She had a death in the family of her grandmother last year. That was her mother figure. She lost a brother who also contributed to her mental state, which made her do bad judgment. So we're asking the court to give her the opportunity to go on probation, do things right, go back, because she's got 5 daughters to go home to, which are in the hands of their family. She has a father that is there, that is willing to support her, and she also has a job that's waiting for her when she gets out. So we're asking the court to give her the opportunity. It's a second opportunity. I know that the facts in her case don't warrant it, but we're asking the court to do so. Because I had long conversations with Ms. Garcia, and I can tell the difference in attitude as to what she has to do in order to continue on with her life. Now, the TAP evaluations are recommending safety, and safety right now is, I know it's a long waiting list, and it'll be maybe a few months before she goes to safety. But we're asking the court to follow the other alternative, which is the outpatient treatment, and put as many requirements on her for her probation to do the outpatient treatment. That way she can go to work, she can go take care of her children, and she can prove to this court that she, and I'm not saying she learned her lesson, I'm just saying she had learned that she has to stop. That's the only words I can come up with. She has to stop. She has to grow up and be there, a parent for her children. And I'm asking the court for probation.
And that's the final verdict: 5 years in prison, with the sentences running concurrently. Throughout this hearing, the defense emphasized family, employment, and a desire to change, but the judge ultimately concluded that prior chances had already been exhausted. Do you think this sentence was fair given her record, or should she have received one more opportunity? Share your thoughts below, and let's discuss it respectfully.
All right. So anything you wish to say, Ms. Garcia?
That it shouldn't have used it, isn't it?
All right, do you want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand. You're going to have to make sure you keep your voice up. State your name for the record.
Amethyst Garcia.
All right. What would you like to say?
That I apologize, that I was in the wrong, that I used an excuse when it's not an excuse, and I've acknowledged that now. I'm not saying that, oh, no, that's the time. No, I know that I have to do what I need to, and I do have 5 daughters, 9, 8, 7, 6, and 5. And I need to be there for them. I do have a job lined up. I do have support from family, and it's time to go on with my...
Brutal. The judge just made it crystal clear. Prior chances wasted, probation is off the table. This is the turning point. The defense's long plea for another shot collapses right here.
My life and to carry on and do what I need to do as a woman, as a mother, and do what I need to do.